up? My name is Dianah Mureithi, as he has said. It's a pleasure to be here. Thank you to the full board of Women on Boards. I am also a member of the Women on Boards. I have been now, I think, for about 4 years. Yes, it's a pleasure to be here and to see all of you women seated here. I was talking to one of my friends earlier, and I said that whenever I have to speak at an event like this, I want to sit in the room and understand the psychology of the people in the room. Yeah, I think I see my friend, someone was in my class over there. So, and understand the psychology of people in the room. Because I speak on sensitive things. I speak conversations that people would rather not hear, but they need to hear. Okay? So, as I talk today, please, what he didn't mention, but I only mentioned because I think it's useful, is that my master's is in clinical psychology. So as I talk today, we've had an AI person, we've had a finance person, we've had a HR person, and mostly you think I'm here as a legal person. But please think of me also as a clinical psychologist. Think of me as someone who's had exposure to both the law and the social part of family and wealth. Then evaluate what is useful to you and live with that. Whatever you find not useful to you, thank the Lord it's not happening in your lives. Okay? And then leave that alone, discard. Okay? That having been said, I think, is it ready? Oh yes, so you can move to the next slide. So Sterling Law, I am a co-founder and partner at Sterling Law. We do tax, legal, and private wealth. You can just move forward. Yeah. Okay, yeah. So as they're going through that, I know what the first slide says. Maybe let's start there. Why continuity? You know, when I received this topic, I get a lot of topics. I get legal ways to protect your wealth. I get loopholes, tax planning loopholes. Wealth taxation, I've just come from an interview where I need to develop a law, a model law on something. So as in, why continuity? When the people of, when the Secretariat and the board of WOBN said continuity, I'm sure they must know something based on the information and the feedback we give. So I'm hoping to get from at least one of the lines, why continuity? Why would you be sitting here today to talk about continuity? Just anyone, please. If there's a mic going around, or you can just speak up. Tell us why continuity? Just? Somebody was speaking on this side? Please talk to me. Encourage me by talking to me. Why continuity? Anyone? There's someone there.
Because the world will not end with me when I die.
I love that. Because the world will not end with her when she dies. Why continuity? Anyone else?
Yeah, for legacy purposes.
For legacy purposes. Can I ask you to tell us what is legacy? Because legacy purposes, if you don't know legacy, we don't understand you. What is legacy?
It's the continuity of the family.
The continuity of the family. So the family here. So why continuity? Because family. Next. Anyone else? There's one behind you. There's a mic behind you.
Life must continue despite all the things that are there.
In fact, I love that answer. I was hoping that that answer comes because life must continue despite all. Death is one thing. Family is another. But the continuity we're discussing today is continuity for even today. Some of you are in legal positions where there is not going to be continuity. Because the kind of facts that would be presented in a court would say, no, doesn't work. It's not a marriage. No, she's not a co-owner of that property. No, there is no proprietary or beneficial interest in that property. So you might be thinking you're in a thing that can be continued, a legal risk or a legal right that can be continued, but you're actually in one that cannot be continued. So we need to also consider why continuity for today. A last answer on why continuity? Yes. No, there's a mic here.
Me, I'll read a Bible verse.
I love it.
Proverbs 13:22. A wise and a good person saves and plans ahead to leave money or property, not just for their direct kids, but for their grandchildren too.
Perfect. I love it. All of us love a proverb. Not that for the
Proverbs 13:22.
Good. So not just for their children, but for their grandchildren as well. Actually, that's a good place to end. You know, last year at my birthday, somebody asked me, my birthday is in December, what has been your life lesson? And last year was a good year for the farm, but it was a bad year for some of our clients. And I said to that person, I said at my party that this year I have seen too many people with too much wealth and too little life. Just think about that for a minute. Too much wealth and too little life. You can't even pay back. Like, it doesn't matter that you're a billionaire at this point. Those billions are not helping you. They're not helping the people you're leaving behind. So as I speak, let's try and see us. Let's try and consider our facts. Let's try and ask ourselves questions about where you're actually at and what is this thing you're trying to create continuity for. And in the first place, are the strands well knit enough that they can actually be continued? Or do you need to do something about knitting together the strands today before we even get to continuing? So there's something called lifestyle businesses. It's a trend we're seeing. I also teach at Strathmore, and one of the things we are seeing is, as we're trying to look into case studies, is lifestyle businesses. The founder dies, the business dies. Can you imagine the effect of that on an economy? We have a whole sector, particularly the education sector. I think I can mention that because it's in the public limelight. As you're aware, the amount of schools, private schools there are sometimes even can exceed the amount of public government schools we have. I think government and private sector in the education are sort of 50-50 in providing education. And what we're seeing in like the schooling industry, a founder dies, the school dies. So can you imagine that this family, if it was, let's say it was my family, my dad worked so hard to establish that business so that we can, you know, have a thing, and then he dies and then we have to restart. Then my children will have to restart. How do we become a multi-generational family, wealthy family, if we're restarting with every generation? If you're restarting with every generation, you can't. If your daughters do not start by sitting in rooms like this because you have sat in rooms like this, then you have not helped anything. You have not created any continuity. Your daughter is going to start the same place you started. But your value in being in a room like this is that your daughter will be able to start in a room like this. Then her daughter, your granddaughter, starts in another room that you haven't seen today. Okay? So lifestyle businesses is a real issue in this country. And we need to ask yourself, if you're running a business today, I like what Paul said about making sure you have your own side hustle. Ask yourself whether your business would die if you died. And you know, some of us here are many consultants like us, lawyers and corporate governance experts. So we are running professional service businesses. I am the business. I am the brand because I'm the lawyer, or Catherine is the brand because she's the corporate governance expert. So what are we doing to create continuity? Because my daughter might not become a lawyer, but am I doing something with the income I'm earning today as dividend income to ensure that my daughter, if she decides to become a pilot, would have something that helps her start on my shoulders, correct? So that's number one. Then necessity succession. Necessity succession is also a trend in terms of somebody just dropped down and died. Over COVID, that happened a lot. People just dropped down and died who were not expected to die, who had no signs that they could die. And then all of a sudden, we have to ask ourselves, what is this business without person X? So we have to look to succession to avoid these things. And I think we've already answered why continuity is important. Now, let me teach you some two words. If, as a wealth attorney, my primary qualification, I am a wealth attorney. If I look at you and I ask myself, what happens to your assets if you die? That's called estate planning. I am seeing you as one thing, as a capital owner. That is all I am concerned with. I'm concerned with the assets you own, and the government of Kenya and the Law of Succession Act is asking, now because there is land in her name, if she's not there, who owns the land? Who pays the taxes that are due on that income? Who administers the things that she was holding? That is called estate planning. When we look at you purely just as a wealth owner and we want to devolve your assets. But when we go deeper and look at you as a human and ask, so exactly what is this life you've lived? So you've acquired all these assets. You've built all this wealth. You have these children. Beyond these children, you are thinking, you hope that they'll have grandchildren. They'll have children and therefore they'll be grandchildren, or they're already grandchildren. You have values. You have things that you have learned in the 80 years you have lived that you think are important for a society, that you think are important for your family. If I look at you from that perspective, then what that is called legacy planning. So that I am going beyond just planning for you as a wealth owner, which I agree it's important to do estate planning. And now we're planning for your entirety and for your legacy. The key goal of continuity or legacy planning, which is what we're discussing today, is twofold, really. One, to preserve the wealth. You've worked so hard to build this wealth. Do you want it to dissipate in 5 years from the date of your passing on? Because otherwise you should have spent it doing other things with it. Or number two, to ensure family continuity, that this wealth does not become a basis for your family to fight. I don't know, is this mic okay? I can hear, okay. I can hear my echo, okay. So basically, when it comes to legacy planning, there's a myriad of things that need to be done. The wealth transfer strategies, which is basically what the lawyers will do mostly. We will decide if the property is owned in your name and you had a will, we will need a grant so that we can transfer the shares. Or we will decide, actually, let's incorporate a trust for you so that if you've passed on, then we don't even need to worry about how the assets move because the trust has not died. We will decide that there's a high, if you have a UK connection, or if you're a UK citizen based in Kenya, we will tell you that there will be high inheritance taxes based on the UK law. So we will recommend what needs to be done to avoid those taxes. There will be business succession planning, which happens mostly at 3 levels. We'll be getting to it: senior management level, shareholder level, and director level, which is a control level. If you are philanthropic and that is one of your goals, that's part of your legacy, that you left behind something, which we're seeing more and more, we'll do the philanthropic structuring. Recently, somebody asked me, why does every family needs to have its own foundation? And what happens when there's no money in that foundation, in the Mureithi Foundation, to keep running it? And now we are seeing a trend where even high net worth families and high net worth individuals are saying, let's find, instead of creating our own foundations, let me put in my testamentary documents that an organization with the following criteria can be given 5% of income from my money as part of my philanthropic objectives. So they will line an organization that supports, let's say it's, they want to support a women organization, an organization that is incorporated for purposes of educating or increasing financial literacy to women, that has existed over the past for over 10 years, that has proper governance system. So you will line a criteria, and then it will be easy for the trustees of the day to look at and say, okay, WOBN meets this, we can give the money to there. Or they will see another, they'll see FOEC and say, okay, FOEC also meets this, we can give the money to FOEC. So then each family doesn't have to keep creating its foundation if they don't want to. But if they want to, and there's substantial assets for managing and operating the foundation, we still do that. Then finally, ethical and personal legacies. I'm sure you've heard of founders who said, our business can never sell alcohol, or our business can never invest in cigarettes. You've heard of founders who say things like that. Those are personal, ethical values that they have chosen, and it's their wealth, so they have a right to say what they want with regards to that. So we look to all that. I will not go through my slides, mostly because we have a lot of, I make very detailed slides because I don't make my slides for lawyers. And because I've also learned in Kenya, we have a serious problem called misinformation. I always write the section of the law I'm relying on, because a lot of people just want to tell you this is written, and you're like, it's not true. So if I tell you that the law says this, I tell you, go read section 36, or go tell your lawyer to read for you section 36, so that you don't feel the need to not be certain whether it's true. So what I've done is that my slides are very detailed, and even though you study them, whether or not you're a lawyer, you will be able to understand them. The other thing is that I know there are many lawyers here, and all of us maybe can take questions later as lawyers, so I don't need to go through this, but I will quickly skim through what I think is important, and then I think we can use the bulk of our time to ask questions. I know the questions for the kind of work I do are sensitive, so if you want, you can start writing your questions, and then maybe later they can be collected. The ones you don't want to ask hadharani, they can be collected and we can answer them. The reason I take that approach is because even though I feed you with with all the information in the world, I might not necessarily deal with the pain points. And for real, I can't even tell you just about trust in 1 hour, Nazisha. And today I'm not even talking about trust, I'm talking about continuity. So let me quickly highlight that if you don't plan your estate, there are certain issues within our law that create room for a lot of people to come in. First of all, from where you sit, are you a wife or a wife for purposes of succession? The law creates a definition for the word wife. If you are married and have a marriage certificate, the Marriage Act deems you a wife, okay? If you are married and have a marriage certificate, you're a wife. If you're married, today is 30th July 2026, and you don't have a marriage certificate, you're not a wife. You're something, but you're not a wife, okay? The law can determine what to call you. You can be called a wife for purposes of succession, but you're not a wife for purposes of the word wife under the Marriage Act. So if you don't have a marriage certificate, call yourself. We'll tell you what other names we can call you. We, the lawyers, will tell you what other names the law calls you. That's the first thing. Now, the second thing is if you are married and have a marriage certificate and it is for a monogamous marriage, for instance, you are married in church or you are married under Hindu, the three monogamous marriages are Christian, Hindu, and civil, or you are married under the AG. Your marriage, while your husband is alive, is a monogamous marriage. But when he breathes his last, it becomes potentially polygamous. Another woman can be declared a wife for purposes of succession, okay? And can be given a right to inherit from his assets, okay? So I want you to remember that. So what do we do with regards to that? You need... Where's the mic? I don't mind. I like the interaction. So where's the mic? You can pass it round. So let me say that again. One, like I said, here, I like, if you attribute anything to me, attribute this. Power is information. If you know better, do better, okay? So the purpose of today is that I leave you here with something you know better, one, and then you go do one thing, do better. 1% only. That one for me, it'll be enough. So let me repeat what I said. If you're married, today is 30th July 2026. If you live with someone and you don't have, or consider yourself married to someone and you don't have a marriage certificate under the Marriage Act, you're not married. You're not a wife. The law has another name for you, but you're not a wife. Now that I'm addressing a gathering of women, I can speak in that gender, we can say the word wife. So you're not a wife because all marriages under the Marriage Act right now must be registered and a marriage certificate issued, including customary marriages, okay? So that's the first thing. Now, the lawyers in the room will tell you what you are, and that is coming up. Now, number two, if you're married today under either civil, so if you're married under Muslim law or under customary law and you have that marriage certificate, then your marriage is a potentially polygamous marriage. The man has a right to marry more women. Under Muslim, up to 4. Under customary, I think no limit, yeah? So that's number 2. Yes, somebody said in perpetuity, that's funny. So listen, number 3, now, we've addressed that. Number 3, if you are married now under the other 3, which are monogamous regimes, civil law, Christian, or Hindu, while your husband is alive, you are in a monogamous marriage. But as far as your husband dies, your marriage becomes, okay, it extinguishes, but whatever setup you had for purposes of succession becomes potentially polygamous. The law has a right to find another woman a wife for purposes of succession. So another woman can be declared your wife, limited for purposes of succession. That is now a factor. So the purpose of such a declaration is that that person then becomes an heir or a beneficiary of your husband, okay? So we will go through what it means. We've just come from a case. I think if you've been on social media, you've seen all the lawyers reporting on a case that came from Mombasa. This case is a bit, it has, like I said, think of me not so much as a lawyer because this case has a bit of dynamics that are very sensitive. This man and this woman, first wife, were married for a long time. And then the first wife left, but never procured a divorce, but has not lived with the man for a long time. Then this man married a second person who the first wife and her children kept calling a Muraj dancer. I think he met her like in a club or somewhere. So he married this second woman, but did not marry again per the law, but they were living together until his death. Well, this man was sick. This is just a factor, but while this man was sick, he got so sick he needed a kidney transplant. This second wife even offered to give a kidney transplant, her kidney. And then I think she didn't qualify, but this was just brought up in trial. Eventually, the man has died and we've gone to succession. And the first wife, because she has a marriage certificate of a monogamous marriage, files as the administrator of the estate and says, of course, I am the only wife and these are my children. So the second wife objects and says, I'm also a wife. Because the Law of Succession Act was amended in 2021 by motion of Peter Kaluma to basically define what a wife is, you can see that amendment that says a spouse means a husband or a wife recognized under the Marriage Act. And I've told you under the Marriage Act, a monogamous marriage is monogamous. So these people relied on that to say this guy had no capacity to marry a second wife, so this woman cannot be a wife. Anyway, the second wife insists she's a wife, and you will note that even despite the amendment for 2021, a second definition of the word wife was still left in the Law of Succession Act. The second definition says a wife includes a wife who is separated from her husband, and the terms husband and spouse, widow and widower shall have a corresponding meaning. So you'll see the word wife as opposed to the word spouse now includes another person. Other than the person in the Marriage Act, it includes a former wife, okay? Then there's another section called section 3.5 that goes on to further expand that definition of who a wife is. This section says that notwithstanding the provisions of any other written law, Marriage Act in Q, a woman married under a system of law which permits polygamy is where her husband has contracted a previous or subsequent monogamous marriage to another woman, nevertheless a wife for purposes of this act. So it creates a further expansion of the definition wife, which now says if me, I'm the second wife, who was married under a system that is polygamous, believing that this man had capacity to marry me, I am still a wife for purposes of succession, which is where I am saying that your monogamous marriage might be monogamous when he's alive, but after he's died, there's other people who qualify to be wives for purposes of succession. So of course, the Mombasa case now, the woman comes under this section. It's called section 3.5. And the court gave a decision that has all of us wondering now, what are we going to do? Because the court calls the first marriage a ghost marriage. I should actually read it for you. Oh, sorry, I forgot my phone here. I wanted to read it for you at this one. Yeah, thank you. The court calls the first marriage a ghost marriage, and then seems to say something we've not heard before, but this is a decision of the court, so until it's overturned, we're bound under what we call stare decisis. Let me read it for you. The court ruled it would be an absolute travesty of justice to allow an estranged spouse to emerge from decades of voluntary absence to strip away property built alongside a dedicated life partner. This is the first time we're hearing the word life partner in the law, but we've been doing life partnership deeds, and I'm sure one of you must know one person who refers to somebody else as their life partner. Yeah, so I'll tell you about life partnership deeds and all that later. So anyway, the judge declared that the law must reflect the parties' lived realities rather than be imprisoned by assumptions and changed from the facts. The court held that because the marriage is anchored fundamentally on because marriage is anchored fundamentally on continuous mutual consent, prolonged physical separation where spouses build entire separate lives constitutes an irretrievable breakdown. So, post this guy dying, the court is basically saying the first wife was divorced. In short, the court ruled that living apart can mean divorce by conduct. Okay? I have not even scared you. That is not even the most scary part. There's another scary part coming. Effectively killing the ghost marriage certificate to protect the true family unit left behind. This is a massive warning to the living that a marriage certificate will no longer shield you from the consequences of abandonment. That is one part. And depending on who you're acting from, you could either agree or disagree with the court. Yeah? But I want to tell you something else that this is now from the Court of Appeal. The Court of Appeal has previously held, in a landmark case, JKS versus JGI, Kenyan courts have structurally refined cruelty and desertion. The judiciary recognizes that physical proximity does not equal legal cohabitation. Cruelty is not just physical assault. It includes the prolonged denial of intimacy, cold silence, and forcing a partner to live like an absolute stranger in their own home. If a partner can prove total cessation of consortium, despite sharing a roof, the court will validate that the marriage has irretrievably broken down. So let me explain what I'm saying to you slowly. Let me hold your hand as I do that. First of all, that marriage certificate you're holding now does not mean that you're the only one. That one we've already established, okay? Now, number two, the court is saying, when the facts are presented before the court, we might actually hold that that's a ghost marriage certificate. Those are the words the court used. Those are not my words. Then number three, we are having the Court of Appeal in a matter that now the third one, the one that I've read, people who had come to apply for divorce, and then one person says, no, we're not divorcing, we live in the same house, everything, then evidence is presented. Yes, we live in the same house, but me, I'm in my own bedroom, you're in your own bedroom, we never have sexual relations. The court is like, no, this is not long-term cohabitation. Just the fact that you live, you have physical proximity does not mean you're actually in a marriage. This is not a marriage. So the court holds this is not a marriage and you have not met the threshold for long-term cohabitation. Okay? So again, the court invalidates that marriage on the basis that there was no long-term invalidation, long-term cohabitation. So what are we saying? In the Mombasa case now, the second wife comes with all this evidence of, if anything, this person was long-term cohabiting with me. If anything, even I offered my kidney for him. This person used, this are the first wife used to live wherever she used to live with her children. They're calling me a Muraj dancer, but for real, I was the person he knew. I was the person who helped him when he was dying. And the court held that she's a wife for purposes of succession, ordered that she be added on as an administrator, and now the matter will proceed to distribution of assets. We're waiting to see how the assets will be distributed based on the facts before this court. Okay? Now, that is even easy because in this case, all the assets belong to the man. I know another case which has not yet been reported where now the assets belong to that first wife who left and the man. And this second wife came and contributed a bit more to those first wives, to what the first wife had contributed. So as a wealth attorney, my question is this: why are you waking up to work so hard for all this wealth only to leave it in such bad structures that nobody can even call it yours? And then you're telling us to teach you on continuity, but there's nothing to continue. It does not even belong to you right now. Eh? Those are the questions I want you guys to ask yourself. So the first thing we've said is, if you have a spouse, when you're thinking about estate planning, you put in an estate plan that covers both you and your spouse, because your spouse's conduct could affect your portfolio. Dependency, the out of wedlock child. Now, a section that I'm sure if you have never heard of. Okay. Yeah, so okay. Yeah, so a section that I'm sure you've heard of is Section 3.2 of the Law of Succession Act, which I will only read the last part. In relation to a male person, it's the definition of the word child. In relation to a male person, any child whom he has expressly recognized or in fact accepted as a child of his own, or for whom he has voluntarily assumed parental responsibility, is considered his child. Do you know how many children your spouse has voluntarily assumed parental responsibility over? We're not even talking about the biological ones. And as I sit here, let me say this: I am a lover of love and marriage. And I was telling that I'm having such a hard time deciding how to present this, because sometimes people think I'm presenting it as a prophet of doom. It's not doom, it's just information. Then you do with that information as you please, okay? Yeah, but what am I saying here? That the law will deem a child who is not biologically your spouse's, whom your spouse has voluntarily taken parental responsibility over, to be his child for purposes of succession, okay? So if you're planning your estate and your assets are commingled with that of your spouse, please remember this: put in place an estate plan for both you, your spouse, and your beneficiaries. Don't bury your head in the sand about who your third-party beneficiaries are, okay? So just remember that. In this one, there's also a similar case. In this case, it was demonstrated by the court. This one was by Justice Musyoka. If you are a lawyer, you know Justice Musyoka is the best of the best. Let me see what he says if it's here. If I can, I like to read it out so that people realize that this is exactly what the courts are saying. Anyway, I can't find the one for Justice Musyoka, but let me tell. Oh no, I've remembered where it is. Let me read it for you. It's on my WhatsApp. So in this case, there was a woman, there was a first wife who was married, and then there was another woman who was not married but was living. Evidence was presented in court that this man would sleep there at least once a week. This man would sleep in the second woman's house at least once a week. At least, could be more, I don't know. This woman, it was not controverted. When the first family filed for succession, they admitted that the second child of this woman was the man's. So they listed that child as one of the beneficiaries, but did not list the first child of the second woman. So the second woman had two children, one born with another man, and then the second one with this man. So when Justice Musyoka was asked to address the question of whether now the first child was called Collins, whether Collins, now the first child of the second woman, was a beneficiary for this estate, he says, are the children of the protester, the second woman is the protester, are the children of the protester children for purposes of succession? There is no dispute that V was a biological child of the deceased. In line with that, she was disclosed in the petition and the confirmation of the application. And there is a proposal for her to benefit from the assets proposed for distribution. So there is no issue with respect to that child. The contest is around Collins. It is common ground that he is not a biological child of the deceased. Ideally, such a child ought not to be reckoned for succession purposes. However, Section 3.2 of the Law of Succession Act provides that such person who assumes permanent parental responsibility over them. However, Section 3.2 of the Law of Succession provides that such child would be treated as a child of a person who assumes permanent parental responsibility over them. Then he goes on to quote many cases, Estate Joseph Masila, David Kavivia, like 5 cases to tell you this is a common scenario. And then he concludes by saying, during the lifetime of such a person, he would have been obligated to maintain this child. And after his death, such a child should be treated as a child of the deceased for purposes of succession. In this case, the first wife had, I think, 5 children. How many children now are there for succession? 7. The 6th one is not even his biological child. So as you sit there and your wealth is commingled with the wealth of your spouse, ask yourself who the law treats as your beneficiaries. Not just your biological children. There may be children born not even biologically to him who are deemed children for purposes of succession. And this is in testacy if you don't plan your estate, which is why we hope you live here and plan your estate. To conclude on this, you want to remember that if you don't plan your estate, all children are equal. You also want to remember that there's a provision within the Evidence Act that says that if we cannot ascertain the paternity of a child, we only need to ascertain that in the period the child was conceived, the mother and the proposed father of that child were living together and looking like, in the same house and that. There's a section within the Evidence Act for that. So again, that's another category of people we can import as beneficiaries if evidence is brought to that extent. Now, this is the interesting part. This is the one that people that now... let me say it this way. Once, when I was a young lawyer, I had a boss I love up until today. That boss of mine, I was doing a talk like this. And then I think I said clandestine lovers. I think I said it like 3 times. He called me later and said, Dianah, when you talk about those people, don't call them clandestine lovers. Men don't like that. You call them other marital relationships. So now I don't call them clandestine lovers. I call them other marital relationships. So let us talk about other marital relationships. Now, this part is sensitive a bit because, as I've said now, the Supreme Court has already ruled and said that marriage is a legal contract. It has said that marriage is being a contract, you actually need to get into it. It's not enough to act like you want to do it. If you actually don't do it, then we might not find you as married. So for purposes of the Marriage Act, as I said, you will only be deemed married if you adhere to the whatever is in the Marriage Act, which all of it requires a certificate. But we are seeing a lot more of people living together, people carrying out themselves as married to each other, and doing all the things that normal married people will do, including taking up the names of the other person. The other day I had someone who was asking how they're going to let go of the name of the spouse whom they never married, but they already went and changed their ID. So now you have to file a deed poll because they changed their ID. So funny. And then the funny thing in that matter, this person is not the one who filed for divorce. The husband is the one who filed for divorce. So the husband has filed for divorce and he has a decree absolute and doesn't care about what you do with your life after that. But now she has his name. So she's doing her best to, how do I let go of his name now so that I can move forward? Yeah, so it was so funny. So anyway, life partnerships. So what are we seeing? We've seen an evolution of relationships. Now, more and more people are calling themselves life partners. What our law currently provides is, whereas there are 5 marriages, the ones I told you under the Marriage Act, there is something called a presumption of marriage, which can be termed as the 6th marriage. It's like a common law marriage. It's a situation where when both parties are alive, because I've already talked about the dead part, now I'm talking for when I'm alive. When both parties are alive, if we have lived together, we have children, we have treated each other like we're married. We've been introducing each other at Women on Boards and other places as my husband and my wife. I have a right to move to court and tell the court, presume me married to this guy. Yeah. So a person can file for a presumption of marriage application and then have the court declare us married. So that risk causes people, especially ultra high net worth and high net worth individuals, to then need to have a structure that makes sure that no one is going to wake up and ask to be presumed their spouse. So what technically lawyers like me do is we draft life partnership deeds. So you'll hear a lot of people telling you they're life partners. Some is loose, but some is actually backed by documents where it's drawn more or less just like a prenuptial agreement or a postnuptial agreement, because even the person who's moving to court to tell the court to declare them married, it's not because that they want a declaration of marriage. Is because the second order after that is either now divorce us and give me matrimonial property, or the second order is so that they can assert under Section 17 of the Matrimonial Property Act certain proprietary interest on the matrimonial property. Okay? So people don't move to court to tell me presume married just for the sake of them having a paper. It's because there's a property interest behind it that you want to pursue, and you can only pursue once you are deemed a spouse by the law. So what are we seeing? We're seeing people who are actually, and this is happening mostly with the divorced crowds, and actually the ones who are coming from the corporate mostly, where they'll be like, so both me and you are now together, and even let's say we're living in my house, but because I don't want a situation where if I've died, you start fighting with my children, we have a clear life partnership deed that says that whatever we have here is just a life partnership. We are not married for purposes of any law, not the Law of Succession Act, not the Matrimonial Property Act. But if I died, you can continue living in my house, say for the next 6 months. In that period, wewe jipange, then toka, all my assets will devolve according to my trust or according to my will or according to whatever testamentary documents I've created for myself. Okay? And then the same would happen to now the wife, the life partner. So a lot of them are loose, but some of them, I'll tell you, I have myself have drafted them. I know there's been questions as to whether they're anchored in law, but the issue has been the risk. So in the UK, it is specifically provided for in the law. They call theirs cohabitation agreements, which is why sometimes you'll hear a lawyer say cohabitation agreement or life partnership deed. In South Africa, they have a specific law on that as well. So in Kenya, we don't have a specific law that says you can do it, but as you know, under the law of contracts and privity of contract and the Matrimonial Property Act, it allows for people to enter into agreements as regards how their property would be owned or done, anything like that. So we are seeing a crop up of life partnership deeds and what we are calling life partnerships. But as I've told you, if not done, then this woman or this man, or Muslim woman, because we don't have any marriages that are allowed to be potentially polyandrous. Yeah, we don't have any marriage situation where you are, as a woman, you have a right to marry 2 men. I don't think there's even any culture that allows that. So all our marriages could be potentially polygamous, but not potentially polyandrous. So we have that happening. The other thing we're seeing is, and again, as I've said, dynamics of a family. This is a true story. Me and my friend, she's a litigation lawyer in family law. I sit and I'm like, oh, by the way, what are you seeing? Like I just randomly ask her, what are you seeing in the market right now? Then she tells me, I had an interesting client yesterday. Husband A came with wife B. Husband A and wife B, both, I think they have 2 homes, I can't remember. So or they still live together, I can't remember vizuri. But basically, wife B has boyfriend D, and husband A has boyfriend C, girlfriend C. So they came to see the lawyer so that they can ask, as to we're gonna stay married because we want our kids to believe we're married and to grow up in a family, they're married, and our corporate profiles don't allow us to start having a nasty divorce and we own all our assets together. I know her man, she knows his woman. We want to know, how do we protect the property we have so this one and this one never claim it? So they have come to the lawyer to ask that question. We want clarity, both of us. What structures do we put in place? What structures do we put in place? Because we're not going to get divorced. we're not going to get divorced. I've seen a lot. This ghost marriage certificate thing is going to be bad because I know I've seen a lot, and there's a lot of especially high profile couples who don't get divorced because they just don't want the drama around the divorce or even the societal pressure around it. But we need to make sure that the property cannot be touched by this one, cannot be touched by this one. That's a simple. The answer is simple. We create a trust and then move all the trust assets to be the beneficiaries of the trust would be children of A and B. Not A and B and their children, because B could go and have children with somebody else there, making that a beneficiary. So we create a trust here. A and B move all their rights here. And then when we name beneficiaries, we could name A and B in their specific names and say, and give specifics. Your right as a beneficiary could terminate on the following conditions or death or something like that. Like we make very clear needs for A and B. And then say that now future beneficiaries are children of the children of A and B. What that has done is that it has eliminated any children B has on this side, has eliminated any children A has on this side. So simple solution created and works. But as a psychologist, I'm left wondering, have we gotten to this place? Have we gotten to the place where the quality of our lives is coming down to a dollar bill? Like at the end of the day, the only reason I am here is because of the money. And then I'm like, did I work so hard for this money, for it to control me like this? I don't know. I also don't have the answers to those questions. I am also one of you. I also have relationships that are complicated. But I am asking that I think people, let me tell you something. I was in a conference in London for wealth planning in March. And we sat, and finally at the conclusion, one of the leading wealth attorneys said that because of how stringent the taxes in the States are, sometimes whenever we plan an estate for anyone who has a connection to America or has substantial assets in America, we have to let the American lawyers take lead because they have such complexities. In America, it's so complicated that sometimes you saw Jeff Bezos needing to move from Washington to say my home is now in Florida, just so that it's not deemed a taxpayer for purposes of capital gains tax in Washington when he sells shares of Amazon. Like those are specific things that have to happen because of how their law is drawn. So one of the leading wealth attorneys says, from one of the American firms, says that she had a client who had to stay out of state X for like 10 years because of the tax implication. But then when he came back, his wife died. He came back, let's say he's come back in January of 2020. In like June of 2020, his wife died. In December of 2020, his son died. And then in the next year, 2021, a daughter died. So this guy could not, for tax reasons, even be with his family. But then when he's finally managed to come back, all of them die for like weird reasons. I can't remember why he died. And at that point, she asked us as wealth attorneys, are you guys also telling your clients quality of life matters also sometimes more than money? And that's the same question I want to pose to a couple like this, that at what point are we going to consider the quality of life? At what point are we going to consider that your daughter is watching you? And so this wealth that we protect, so that trust, we may have paid a higher price for it, which is this daughter and the kind of things she grows up thinking in her mind. You know, like I really want people to actually sit and ask themselves why. Yeah, so that's important. Anyway, if you decide the first one is your thing, I've told you the solution, the trust, and then name the children of your children as the beneficiaries, not you guys. So those are just some of the risks, as you can see. Those, we call them legal risks on a portfolio. As you can see, those are just some of the social dynamics going on in your lives that affect a portfolio and that affect how your wealth performs. I've come back here because I've already told you about the people who refuse to divorce, and now that goes marriage, whatever. This case was in court. I should actually make mention of it here. It was on the Nairobian. I'm sure if you've read the Nairobian, so far we've had two high-profile trust cases, the Jenga Karume one, and now we have the ongoing one, right? It was on the Nairobian, the Muguku one. The key thing that is trying to be asserted in that matter is a formerly divorced spouse who knows there's a trust somewhere but doesn't know details of the trust, has had their lawyer file a document in court to ask for, to assert the rights for her children under that trust. Of course, there's a lot of, the lawyers here will tell you, just from what I have explained, there's a lot of fundamental legal issues that already come up with just how that is framed, because under the Constitution, everyone has a right not to self-incriminate. I don't have a right to come and give you information that you would use against me. I have a right to refuse to give it to you because you'd use it against me. Yeah. So that's number one, but that's ongoing. So question here is post-divorce. If you are claiming or your children are claiming entitlement to certain assets, do you know the way that those assets would reach your children? Or are you just sitting there and saying, oh yeah, they're in a trust somewhere, so another woman cannot get them, but can your children also get them? You know? And then the other side is also true. If you yourself now are sure that your children can get them, do you know the rights for third parties to make a claim on that trust? You may have seen on the dailies a prominent family where DNA was declared and everyone has to test to DNAs. When you draw trustees, many times we will say either you will subject yourself to DNA testing of the trustees choosing, and we can say up to 2 or up to 3, or whatever claims you have are obsolete. And because you're the one trying to come and make the claim against the trust, you'll either have to do that or they're obsolete. And there's nothing, the court cannot force any situation because the trust does not owe parental obligation to anyone. Okay? The people who owe parental obligation are parents. That is why a trust can lock out the child of this guy B over here and this child of this one. Because the trust in itself is a corporate body incorporated for the benefit of its beneficiaries, to be run by its trustees and overseen by its enforcer. So a third party would need to make a direct nexus to this trust. So if you don't fall in those 3 categories I've said of beneficiary, trustee, and enforcer, what is your basis for coming to ask the trust anything? Okay? So ask yourself if there's a trust involved, whether you know how your children would take benefits, and whether you know if in your own trust how third parties would, if they try to make a claim, would take benefits. I think the other risk we see that is not talked about a lot is critical illness. I'll be quick with this one. We are seeing an upsurge. I think I talked about this at the last Women on Boards event I did. We're seeing an upsurge in mental health illnesses. What the Mental Health Act says is that if you don't give us a legal guardian who takes care of your things when you're not of sufficient mental capacity, then your beneficiaries have a right to approach court and then ask for someone to be appointed. Yeah, the process can be very gruesome. So what we're advising here is if you know anyone who has either gotten a diagnosis or, because again, the other thing about our African setup is we know someone has a diagnosis, we know that the doctor has said that that is dementia, but none of us wants to say it's dementia. So we'll keep acting like it's not dementia. And even they're signing documents and doing other things. But then the people who want to fight will just watching you do that because later they will come and say everything he did was not in accordance with the law. So if you know anyone who's suffering anything like that, we encourage that they do a power of attorney when they're still lucid. The law allows that when you're lucid, you can do a power of attorney and give up specific powers or all general powers. Specific means you go ahead and say power to make medical decisions I've given to my sister, so then there wouldn't be issues as to whether pull the plug or don't pull the plug or my children, there wouldn't be a fight as to what needs to be done. This last week, I acted for a man who gave that power to a third party, like not to his family, he has 2 wives, not to his family, to a friend, another young man. And when I asked him why, he said, this one's will be too emotional. No, none of them will make the decision I need to make, but that one, he will do exactly what I need him to do. So ask yourself questions like that. If you know anyone who has anything like that, you can advise them on the powers of attorney. I will not discuss the rest, but you will see them there. So family business. Now, because we're at Women on Boards, it's important to discuss this. You have a family business or you have a business you're running, it doesn't even need to be a family business. If you have a business, also when it comes to succession planning, we have to ask ourselves who would take over control. That's number one. That is, who would be the next set of board members? How are they appointed? Are they the people you would want to be in charge? Because they're the ones who get, the company has not died if you have died, God forbid. And this applies for both a holding company or a trading company or trading or holding structures like LLPs and all of that. So first of all, do you know who would take up control in your absence? Control is both corporate governance as well as a legal issue in terms of the Articles of Association will have told us how a board member is appointed, and that has to be followed. If there's no other board member available, the Companies Act is clear on how they would need to appoint who else signs for new board members to come on. So if you're running a one-man board, that's what I mean. Then number 2, senior management. You have to ask yourself specifically at the senior, because some of the roles you're doing in your family business or in your holdco are both board level and senior management level. So who would be able to do that? For this, we usually draw something called family employment policies if you're dealing with a family with a family business. If we're dealing with a holding company, we usually just entrench the trust within the articles of association. So that the governing body of the trust would be able to make the decisions. Family continuity systems, that's if you want to, family constitutions, family councils, it just tells us how decisions will be made. These apply if you have big families, but these days I'm seeing more and more people who have, we did like between like the last 5 years, we stopped doing a lot of family constitution, but all of a sudden this year, everyone is asking for a family constitution. So more and more, the key thing we want to remember about all these other documents like family constitutions, create a legal nexus to the legal document, because to a company does not know what is a family constitution. So it needs its articles to reference the family constitution and make it an annexure within the articles for it to have legal force. And then if there are other related assets, for instance, if you have a building, you'll hear someone, I have a building, the factory or the land is held in a different company. So look at the ownership structures there. Of course, you know the effects of joint ownership of assets versus tenancy in common. Tenancy in common is where your rights are severable. The title says that I own Dianah and Sheila own the title. Dianah owns 60%, Sheila owns 40%. That's a tenancy in common. So if Dianah dies, her 60% devolves to her children, and Sheila dies, her 40% devolves. Joint ownership is where we just written our names. So it's Dianah and whoever John, and then it's not, the rights are not severable. So whoever dies, their right abates. So it becomes, if Dianah dies first, it becomes John's, absolutely. So you need to check your titles and confirm whether the assets you're holding are owned in jointly or tenancy in common, and whether by it devolving to the other person absolutely is what you would want in terms of continuity. Then personal bank accounts, because obviously everyone keeps bank accounts. An important thing I've seen, I had a client who did basically a lot of their wealth. They had a lot of investments in, say, bonds. And what they did is that they created all the accounts, the underlying accounts for the bond with the beneficiary. So for instance, if I want you to get 33% of these bonds, the ones I have, they created account one, me and my father and me. Then the other one, my father and the sister. Then my father and the third sister. So that prevents a situation where me, I have to go to my sister and none of us need to go to court, because all of these are joint accounts. So if my father has died, it becomes mine absolutely, becomes my sister's absolutely, becomes hers. So we are seeing more of joint arrangements. I even have a client who got a prognosis for no more than 3 months. We couldn't have finished planning the estate in more than 3 months. So what they did is we had all the shares in all the companies owned jointly with his wife, who was in good health. So now, God forbid, if that man dies, all the shares will revert automatically to the wife without us needing to contest with anyone as regards to whom they should go. Then now we are doing the planning with the wife, because again, now the man is very sick. We can be able to do much with him right now. So that's joint ownerships can be used sometimes to your advantage. If, for instance, we have a little time, or for instance, we can already see the sort of that party interest that would come up and we want to limit them. Yeah, other than in a family business, let me just mention this. Other than the legal stuff, you also have to discuss a lot of other non-legal succession tools, like what is the vision, the value, the dream. You need to hand over to your beneficiaries a business they have understanding of exactly where it's supposed to go. The company organogram, which helps them to know the current gaps and the future growth. And then leadership systems, so that decisions are not made at the breakfast table. Succession planning beyond the board. Now, again, you have to go beyond the board when it comes to a family business, because you need to tell us how middle level and supervisory level would be succeeded, because your children maybe have not been involved in running it, so they might not know who to choose and who not to choose, or who you found useful in the business and who is not. Then finally, family liquidity planning. We're seeing a lot more people now use life insurance to balance liquidity issues post succession. So what we are seeing is a situation where if I have life insurance, I would state that either it would be paid out. So I've seen 2 scenarios so far. A family business where the father can tell that 2 brothers are not involved in the business. One brother does a lot for the business. And he says, I don't want these guys to want to come and want to take over the business just because they want 33.3% of the business. So what do I want? For my life insurance, brother A and brother B will get 35%, 35%. I think they got more. They're getting a higher share. But then brother C, who runs the business, will get the business and then get a smaller share from the life insurance. So what that has done is that it has mitigated these 2 from coming to fight the family business, and therefore in those fights, the family business going down, yeah? That is one way we are seeing the life insurance being used to deal with liquidity. But also we are seeing a situation where with the key man dying, the kind of jobs they used to get, they won't get. So we can see the life insurance being paid out into the trust, which will then be able to inject capital into the life business as a shareholder from the life insurance proceeds. So that sort of carries them through the process of transitioning the key man. So if you have a family business, you have to start asking yourself questions like that, because failure to ask those questions is why your children will start to fight, and some will start to feel like, let's sell the business, or the business is not giving you the money I expected. Yeah, so I have already done an in-depth look at all the tools. I don't need to go through that. I have talked on trust many, many times, so I don't think I also need to do that. But before I close, actually, I think I need to do it. I think maybe I should let you ask questions. You can tell me, do you want me to talk about trust a little, or do you want me to just, okay. Okay, fine. Let me talk about trust a little, because ultimately, I tell people that the issue is not that we're just saying incorporate a trust because it's a buzzword now. Is that number one, yes, the law has changed and has evolved, but number two, in terms of the options you have under the law, and I like to tell people, life is lived in context. Yeah, these are the estate planning tools you have. If you today you're asking yourself how to plan your estate, there are 5. Those are the only options you have under Kenyan law currently. And then under wealth management tools, those are the options you have. You'll either have holding entities like holding companies and LLP structures. You'll have offshore arrangements like trusts and foreign entities, or you will have a nominee or a proxy or a corporate trustee. The interviewer was mentioning here, they asked me, how would you determine like wealth injustices? And I was telling them, even though you do a search today and find out how many trusts were incorporated in Kenya, it doesn't tell you anything about the wealth injustice. For me, a better measure is do a search on the buildings you see in the CPD. Find out who owns them. Then you find out all lawyers are listed. Then it tells you where the real owners of property are. Those are proxies and nominees, yeah, and what we call legal arrangements. Yeah. So what was I saying? So those are wealth management tools. Then estate planning tools are those ones. Power of attorney, I've already discussed. Gift is when you give your gift when you're alive. And the key thing you want to remember here is tax planning. If my father transfers property to me today in my name, he doesn't pay CGT because his name appears on my birth certificate, but I still pay stamp duty. So if it's property worth 100 million, that's 4%. That's 4 million. 4 million is money. You can buy some nice shares in the NSC. So tax plan around it where there is opportunity for tax planning. And then loss of control. If you give a gift and the title is now mine, it's mine. There's not much you can do about it. Then forms of nomination, this is important. If you have pension benefits, insurance benefits, or SACCO shares, you need to check your form of nomination and ensure it's updated. These don't go to probate, so ensure that it says the person you want it to go to, which is what I was saying about the life insurance. If you're using life insurance, then we can have the money move into the trust as opposed to going to one person. Wills, this one I am not stopping to sing this song because I think the most horrible thing I have seen in my life, and I am a lawyer who says a lot of things, but maybe I feel like this because I'm also a mother of young children, is 2 things. The other day I was telling a client who's a divorced client who's aged about 37, I was telling her this story. And then I tell her, there's a story where parent A and parent B are matriarchs and patriarchs, they're old, they only had one child. That one child was married to one man, and then they had a child who was 3 years. Then that daughter died. So when the granddaughter was about 3 years old, the daughter died. What the son-in-law has done is proceed to say, if you guys don't transfer the following assets to me, I'm moving your granddaughter out of jurisdiction. So you can imagine how sad these grandparents are. These are very high net worth, high value grandparents. And they are, on one hand, can see this is blackmail, but on the other hand, even though they're left with all this wealth and they're in their 80s, if they never see this grandchild and this is the only daughter they had, what is the value of this wealth? So they are caught literally between a rock and a hard place. And this son-in-law does not seem to care. He's very clear. My condition is I need asset A, B, C, D, E. Because see, your plan was to give it to your daughter. Why aren't you giving it to me? See, your daughter was also my wife. So anyway, that's a real case scenario that's happening. What does that mean? What does that mean? If you don't leave, I don't know whether you know this because some of you here might be approaching grandmother status. If you know as a grandmother, what the Children's Act says is a parental responsibility vests in the parents. So if God forbid I've died, my spouse, a stranger or not, has a parental obligation and responsibility to our children. So most times he'll be the one who has the direct right to take up custody, actual custody and all of that. If I didn't leave a direct nexus for these parents to engage, they might not have basis or what we call a course of action to go to court for. unless they start with going for criminal things for neglect. The children have been neglected. So the children might not necessarily be neglected, but they might just be in a bad space. Or you could, as grandparents, be able to offer a better space. What are we telling people? If you have children below 18 or below 25, please, in your testamentary documents, bequeath guardianship. That does not mean I have denied my surviving spouse the right to raise his children. No. It just means alongside him raising his children, I have left someone who stands in my place, whose rights will be determined by the court or whom they'll agree with that person. Once in a month, they'll visit. Now, we're going a step further. Like in my trust, it will say, because my sister who would be the guardian is also a trustee, the children would be required to visit my sister once a month or every holiday. And then wherever they're going for holiday, it is paid for by the trust. Yeah. So I'm not burdening my sister to do anything like that. So we create provisions that allow that somebody who's tied to me would be able to take care, to watch the welfare of these children. And then again, as a guardian, if now she observed that this one comes every day looking funny, or this one has started having funny behavior, first she'd have a place to get involved, even to see that behavior because of that guardianship being bequeathed. But number two, she'd have a basis to actually go to court without needing to claim neglect and other criminal, outrageous things. To go to court and say, as a guardian, I am observing this is what I am asking for, okay? So guardianship is not that we are denying the surviving spouse rights. We are not. We're just saying, in case there was ever need for someone to defend that child, I have left a direct link. People will not start looking and wondering, how do they defend this child? They'll go to lawyers and be told you have no cause of action. Okay? So if you know people with children below 18 or even below 25, because the law allows for extension of parental responsibility as far as a child is still in school, typically usually to the age of 25, you can leave that in as you can bequeath guardianship in your testamentary documents. That's your will, and then also tie it in with the conditions of your trust. Yeah. So I will say that if the trust is paying for school fees and medical and whatever, they need to see my sister or they need to see my grandparent, my mother, once every holiday or something like that. So what was I saying? The reason why trusts have become a buzzword is because these are the options you have in law. These options, based on just the explanations I've told you, are limited in one way or another. A will is only operative upon death, meaning if dementia has kicked in, we cannot read your will. Gift inter vivos, you have lost control. It's no longer your asset. Form of nomination, only specific asset classes. Doesn't cover real estate, doesn't cover your bank accounts. A common misconception is that it covers your MMF. It doesn't cover your MMF. Your MMF is in the category of personal bank accounts. So again, very limited in scope. So what a trust does, and I think that is what people need to understand, is that it is both a succession tool and a wealth management tool. The other ones at the bottom here, the hold cause, the nominee arrangement, and the offshore trust are just wealth management tools. If I am having an offshore entity, it can protect me against some levels of political exposure. Or if I am having the other thing, if I'm having, oh, okay, I don't know where it's gone. Yeah, so if I'm having a political exposure, I could use, say, the trust, or I could use the nominee or proxy arrangements. So the other ones are wealth management tools. So they will assist when I'm alive to a certain extent, but they will again not help with succession. So the trust is the one that covers both. It will do the succession planning as well as cover the wealth management tool, and even to a certain extent cover something that is not here, which is called family governance. Yeah, because when we do these things, we also have to consider family governance. So let me go directly to trust. A trust is created by somebody called a settlor. It is run by somebody called a trustee. That's akin to a director. That's the mind of the trust. And then a beneficiary. The difference between a trust and a company that I want you to remember is, in a company, a shareholder owns their shares, okay? That's a unit of property. In a trust, there is no owner. The trust owns its own assets, and that is where the protection comes from. Beneficiaries simply receive benefits according to the trust deed, and that is where the protection comes from. So that if I am a politician who's politically exposed and they have said they're coming for my assets, even though I am named in this trust, they're not my assets, they're trust assets. If I am a debtor, a creditor, those words confuse me. If I owe KCB money, that's okay, whatever it is. If I owe KCB money and KCB has a decree against me, KCB cannot attach my trust assets because, again, they're not my assets, they're trust assets. Again, if it's a matrimonial property claim, Section 6.2 of the Matrimonial Property Act is clear that trust assets are not matrimonial property. But more than that, the trust is not married to anyone, so you cannot make a matrimonial property claim against it. If it is a succession issue, the trust has not died. You cannot make a claim from it. If you're claiming to be a child out of wedlock, the trust is not your father, so you cannot make the claim against the trust. You can only make that claim against the estate of your father or the estate of your mother, okay? So the trust, because of that corporate, whatever, personality, creates a lot of protection. And an important thing to note is trust world over apply on the same phenomena. This is not things that apply in Kenya alone. I actually had a video I wanted to show you because today when I was putting coffee, I saw that that vending machine is written Godrej vending machine. What a lot of people don't know is that that Godrej family is one of the leading families in the world. I think they faced some drama in India at one point before deciding to set up their wealth as a trust. Yeah. So these ones apply everywhere. If you're setting up a trust, the most important thing is know your objectives and then know your apprehensions. I think these slides will be sent by Women on Boards to all of you, so don't feel pressure to like keep up with me. You'll have them in your inbox. So the settler's vision, what are you trying to achieve? Let us be clear about it. If you're trying to mitigate a risk, I have a trust that's being incorporated for 35 years because we just need certain things to pass and then the assets can devolve directly to these people. Then I have a trust that needs to exist in perpetuity because the kind of wealth we have needs to get to the third or fourth generation. So be clear on what you're trying to achieve. The second thing is the settler's apprehensions. Whatever dynamics are playing out in your family, please do not lie to your lawyer. First, please do not lie out to yourself. I've already shown you how they will play out in court. Please do not lie to your lawyer. So be sure of those dynamics and then mitigate against those dynamics. That is the apprehensions you're seeing. That slide just gives a difference of what is a vision versus apprehension. I want to say this. If you create your trust when you're alive and you move any asset, including 1 shilling into it, it's called a living trust. If you provide in your will that your assets will go to a trust, it's called a testamentary trust. Don't create a testamentary trust that is subjecting a strong structure to a weak structure. Because if the will is invalidated and fails, then the trust idea also falls away. Number 2, level of control. A revocable trust is where you decide to leave a right for you as the owner of the asset, the settlor, to revoke these assets and call them back to yourself. Where you say you don't have that right, it's called irrevocable. The key thing you want to know is if you have a debt risk on your portfolio, you cannot create a revocable trust because your creditor can move to court to compel you to revoke it so that they can attach those assets. Again, you've made a strong structure weak by poor structuring. So that's a revocable versus irrevocable. And then finally, fixed and discretionary. If you want control, the concept of trust is own nothing, control everything. If you want control, when you're alive, have discretionary mandate. So you would be able to make all the decisions you want in this trust. Then the mandate can fix with your death. Your death can be the factor that causes the terms to fix. So if I have 3 children, then I'll say upon my death, all the distributions, whether for income or capital, are in accordance with equality of lineages. So it will be divided by 3, 33.3, 33.3. So you need to have a mix of that in your trust. Rarely do we create a trust that sits as a trust alone. This is a common mistake I'm seeing being made now. The other day, someone called me, like 6 months ago, last year, someone called me, told me they've moved a building in Kericho directly to the trust. That is not allowed. The trust is an untrading entity. So if you have a commercial property, it has to be owned. If I have a commercial property called, this place is called what? This place, Diamond. If I have a commercial property called Diamond, then I have to first create Diamond Limited, then have the trust own the shares of Diamond Limited. You can just send a commercial property directly to the trust. That is bad structuring. It's against the TPSA and against taxation laws. So you will create some weird dynamics and high onerous tax obligations on yourself. So the key thing is we will create holding companies mainly. Finance Act of 2026, the best thing it did for me, it clarified Section 11, which is a taxing section, Section 11 of the Income Tax Act, which is a taxing section for trust. It said that as long as the income entering the trust is either dividend or interest income that has been paid on withholding tax, we call that qualifying dividend income or qualifying interest income, then no further taxes shall be paid from the trust when you distribute. What that just simply means, because you're not all lawyers, is if there's a holdco and the money passes through the holdco, no more taxes are payable. We've clarified that tax question. Now we don't need to keep arguing about it. That was in the Finance Act of 2026. With regards to trading entities, we will structure them. I feel like I don't have enough time to explain this structure, but I think I've explained it in previous meetings, so I hope you're clear. But what I want you to know is, now my value as a wealth attorney is, when I receive your portfolio, if you have income, rental income, I decide where to place it, whether to go directly to the trust. If you have commercial, I say commercial can go to the trust, so hold in a trading entity X here in the blue company. If you have bonds, I tell you that one is okay. Once you pay withholding tax, there's no more taxes payable, so I can hold it either at the trust level or at the holding company level. It has the same tax position. Basically, I decide based on accounting and taxing principles on where to hold. Yeah. So I think I've already said all these things. The trust offers asset protection mechanisms that we don't currently, unparalleled against any other tool currently. I have quoted that if there is bankruptcy or liquidation or proceedings against the settlor, the trust assets cannot be attached. And Section 6.2 of the Matrimonial Act specifically says that trust property is not matrimonial property. Yes, that is it. I have finished. The advantages of the family trust are tax planning, asset protection, avoidance of probate. Let me tell you something you don't know about avoidance of probate. Right now, I can't tell you, but I know of 2 or 3 high-profile trusts where the things are simmering, but no one in the public knows about them, because the trust requires an internal dispute mechanism that is happening in boardrooms like ours. Yeah, as opposed to what I had showed you when I started this presentation. Somebody is thinking they're a wife, they have rushed to court to give evidence of how he slept at their house once a week. Yeah, that is the comparison. Yeah, and then flexibility and adaptability, and finally the enforcer role. The enforcer role is a role for oversighting trustees. The enforcer role is a role for oversighting trustees. If the trustees were acting badly, rather than the beneficiaries fighting trustees, because many times they are related, they can enforce an enforcer. They can appoint an enforcer who forces the trustees to enforce the terms of the trust deed. I want to close by saying continuity is not automatic. In fact, may I say that even right now, if based on what I've told you, I don't know if there's a thread that's continuous, but let's assume that your thread is continuous. Continuity is not automatic, yeah? It is planned and structured. It is one thing that you've planned it, you've created a will, but have you structured against it, which is what I was saying here. Do you know that there's that person who could be called a beneficiary? And have you created a structure that would cause that person not to come and unnecessarily unravel all your plans, okay? So continuity is not automatic. It is planned and it is structured. Failure to plan is a plan to fail. That is it. Thank you very much.